thank you everybody for joining us today on this program on power of attorney. You know, it's been a popular topic in the news here since we got that blurb a couple of weeks ago. And I thought at that time, you know, be a great time to have one of these power of attorney programs. And so I'd like to introduce Amy Devine with Haskins Short and Brindley law firm, and Rhonda Sweeney from Numb3rs R Us. Rhonda's an accountant and a daily money manager. If you would, Amy, Rhonda, take it away. Tell us a little bit about yourselves and then launch into your program.
Sure thing. Do you want me to start, Rhonda? Okay, so my name is Amy Devine, and I am an attorney at Haskins Short Brindley. We are an elder law firm, which means that we do estate planning, wills, trusts, powers of attorney. We also handle Medicaid work, special needs trusts, guardianships, probate, estate administration. It's all encompassing when we talk about kind of elder law. I also have my master's in social work and a certificate in gerontology. So I've really kind of specialized in this area of legal issues for people as they get older. And thank you for having us here today. We're excited to talk about powers of attorney.
Thank you, Amy. My name is Rhonda Sweeney. I am an accountant daily money manager. I also offer power of attorney, trustee paperwork, and other options for folks that need it. So I'm excited to talk about this issue. I'm very passionate about it. My background is in accounting, but I spent 10 years in multifamily, most of those in senior housing. And I've seen a lot of folks being taken advantage of, and mostly from their own family members. So I just wanted to make a difference. And that's why I decided when I started my accounting firm that I was going to offer daily money management, power of attorney, and trustee services. I know we don't have time for everyone to share, but I wondered if there's if some folks would like to share why they decided why this topic in particular was interesting to them.
Feel free to unmute yourselves and pipe up.
Can you hear me?
Yeah.
Can you hear me? Okay. I signed up for it because I wanted to know more of the responsibilities that a power of attorney has versus a power of healthcare. And they're two different things from my understanding, and I have them appointed, but I just need that definition a little clearer.
Thanks for speaking up, Noreen. We'll definitely cover that.
And I go by my middle name. I'm sorry it's not there, but I go by Sue. That's okay. I need to change it.
I work for the women's community, Debbie Green, and I work for the women's community. I'm a abuse and later life advocate, and I'm working with clients, a couple clients that have been scammed and have lost all of their money and all of their personal belongings to abuse because they were they weren't ready to sign paperwork, but they were forced to. So I'm trying to get as much.
Thanks, Debbie. Anyone else want to share?
This is Alison. I'm interested because we're in the middle of trying to set up a power of attorney and to do our legal paperwork, but also because I read the article in the newspaper recently about a lady who was lost her house. It was sold out from underneath her, and she didn't know about it or something like that. It was in the newspaper anyway. So that's why I'm interested.
Towards the end of our presentation today. Anyone else that want to share? I think we have time for one more.
I see a comment here. Nicole says, I'm here as actually I worked with the person who was in the news recently and would like to know more about how this could happen and how this could be avoided.
Okay, great. Thanks, Nicole. Well, we're gonna address a bunch of like all those topics, and so we have our. Let me see.
I can't hear you very well.
Yeah, sit close to your
everybody-
microphone, Rhonda, if you can.
Oh, is it hard to hear? I put it
No.
far away because I wasn't sure if you could see me.
Yeah, we're fine.
All right, is that better?
Yes.
Great. If you can't hear me, please just go ahead and pipe up. I can't see the chat because I'm manning the PowerPoint slides. So just feel free to just, Mike, if you want to put your hand up by your ear, I can see your image. Well,
Okay.
all right. So we have the agenda here. So we're going to talk about the current support tools, why someone needs a power of attorney, more specifically, a financial power of attorney. What is the difference? Financial power of attorney, explain the duties of a power of attorney, who makes a good financial power of attorney, assigning a power of attorney, how you go about doing that. We're going to talk about the article. We're going to take some questions. And then at the very end will be our contact information. So I'm going to go ahead and turn this over to Amy.
All right, thank you, Rhonda. So just
How are you?
Good.
Good. I was just gonna make a call to the hospital.
oh, I think
Please
If
mute
somebody would like to-
yourselves.
Mute yourself.
so. I'm going to just kind of give a very brief overview of decision making in the state of Wisconsin. And this is from the Wisconsin Board for People with Developmental Disabilities. They have a great site, great tools if you're working with someone with a developmental disability. But this is kind of a continuum about when we appoint someone to make a decision for us, what are kind of the least restrictive ways we can do that, and then what are the most restrictive. And so you'll see kind of at the tail end, if you sign a release form, for example, that's just you giving someone the ability to access your information. We do that with HIPAA releases with our doctors, so that they can talk to someone else on our behalf, but they're really not making any decisions for us. There is a tool in Wisconsin called supported decision making. I've named it here. We could have a whole another hour just talking about what this particular agreement is, but it's really just letting someone else kind of come in and help you make decisions, but you're not giving them any decision-making power either. If you're getting some kind of Social Security benefit and you need someone to manage those benefits for you, you might have a representative payee. So that's kind of in the middle. And then at the other end, where we kind of get more restrictive, we have a power of attorney, and that's either for medical or financial. In Wisconsin, we have two separate documents, and you want to have two separate documents, largely because they are going to address very different areas of your life, but also you might want to name different people to do that for you, right? So I might trust my daughter to make medical decisions for me, but I really want my son to make financial decisions for me. And that's okay, generally speaking, as long as everyone gets along and is going to agree about what's going to happen if I'm not able to make decisions for myself. And then at the tail end, we have guardianship. And guardianship is when you are in court and a judge is now declaring you as incompetent. So they are taking rights away from you to make decisions, to manage your finances, determine perhaps where you're going to live. And that is a decision that is made by a judge in court. And there are due process pieces as part of that. There are attorneys involved for the most part. And so that is what we think of as the most restrictive, right? Rights are being taken away. All right, next slide, please, Rhonda. Okay, so why do we need a power of attorney? In Wisconsin, we are not what we might call a next of kin state. So there is no automatic decision maker for us. So for example, if I am in an accident and now I am not able to manage my finances, pay my bills, open up a new bank account, any of those kinds to to do that for me. If I don't have a power of attorney in place, that's when my husband, whoever, they're going to be looking at guardianship and having a guardian appointed for me to make those decisions. So the idea behind a power of attorney is that it is there when we need someone else to help us with decisions. And if we don't have that power of attorney, then even if we become incapacitated, can't make our own decisions, then family might be going to court and seeking guardianship. So in Wisconsin, once you turn 18, I recommend you want to really think about having something like this in place. Here we did a project for kids going off to college during COVID. Parents were worried, okay, my kid's 18, they're going to college in California. You know, I can't make any decisions for them if they become incapacitated, if they get sick. So even when you're 18, you can have a power of attorney. It's not just as you get older. What you may have heard that Wisconsin is a marital property state, kind of the what's mine is yours, yours is mine, with various asterisks and caveats to all of that. And a lot of things we hold jointly, right, when we're married, but a lot of times we don't. Maybe I have a bank account from before I was married, just my name is on it. My husband will not be able to just access that account without getting that power of attorney or guardian. So we want to make sure that, again, whoever needs access to financial accounts can have that access if and when I ever become incapacitated. And again, the idea is we're trying to avoid guardianship, which is it can be a lengthy process. You're going to court. Oftentimes you're hiring attorneys, which was what can make it more expensive. And ultimately, the judge is declaring somebody is incompetent and taking away their rights. And so if we can avoid that by planning and having a power of attorney in place, we like to try and do that. And I'll explain where even with power of attorney, sometimes that's not going to get you all the way to where you need to be. And you might still be, getting guardianship, even if there's a power of attorney in place. Rhonda, you want to go to the next slide, please?
I'm gonna interject here too as well. I know as a daily money manager, a lot of my clients are elderly or they live in another state. And a lot of times it's difficult to get them on the phone, especially if they're going through a lot of health issues, to get them on the phone at the same time with a lot of their places that they have their bills, and to try to do it after the fact. Like if you're making decisions for somebody because they're ill, to try to get them to get on the phone to make those, give those permissions for those companies to talk to you. It's kind of a hassle. So that's why this power of attorney is really important to get a plan in place beforehand. So.
Thank you. Yes. All right. So kind of to Rhonda's point, sometimes it is too late to kind of get these documents in place. I do have people come in where I say, you know what, I just don't feel comfortable going ahead with this signing. I don't know that you have capacity, or it's oftentimes an adult child bringing in their parent. I can say, I don't know that I feel comfortable having them sign this legal document. I don't know if they understand what they're signing. Again, you might need to have a guardianship if we don't have a power of attorney in place. And then after somebody passes away, this speaks more to really having a will or a trust or other estate planning documents in place. But I get a lot of people who are very angry that something is going to someone else and not them. Mom promised me this. Well, she very well could have, but her will says something entirely different. I can't change that now that mom has passed. We are kind of set with what we have. So again, these can be uncomfortable conversations. It can be difficult conversations, but there are things that we really want to focus on at any age. And especially at some point for some of us, it might be too late to have this planning in place. Next slide, please. Okay, so just when you kind of work with the lawyers, sometimes we get in services, we kind of get into alphabet soup, and you hear all these acronyms thrown around. And I want to make sure everyone understands kind of what these different acronyms are. So you might go to a bank and they might talk about POD, payable on death, or they might talk about TOD, transfer on death. This is something that you can do with your bank. You have a beneficiary designation with your retirement account. This is who you want to get this money upon your passing. So you might name a child, you might name a spouse, you might name your trust, but that is payable on death. You pass away, that's where that money is going to go. A POA is a power of attorney, very different. That's the document we're talking about today. That is you designating someone, you being the principal, designating someone else as the agent to make decisions for you. Now, the other option is a joint account. And this happens all the time where someone, I say, go to the bank, give them the financial power of attorney document, say you want to be added as an agent on this person's account. You want to be the POA. And somehow wires get crossed, and now that person is now a joint owner of the account, which is not what we intended. We intended for that person to be an agent. If you are a joint owner, the law says, joint owner number 1 passes away. That account is now the sole account of owner number 2. And again, that may not be what anyone anticipated. If this is your primary account, you have $100,000 in your bank account, and you meant for your money to get distributed equally amongst your 3 children, but now the person who is your POA was somehow made a joint owner. Guess what? Joint owner number 2 is technically the owner of that account. So again, we want to make sure we understand, what acronyms and terms are being thrown around. And then we also talk a lot about durable power of attorney. Durable just means that if you are ever incapacitated, that power of attorney continues. That agent still has the power to do things. And so for both finances and really in healthcare, that power of attorney is going to continue. But again, you want to have kind of 2 separate documents for finances and for healthcare. Next slide, please. Okay, so the basics. Wisconsin kind of did an overall upheaval of our power of attorney for finances laws back in 2009. So if you have an older document that is dated prior to September 2010, you still have a valid document as long as it was signed in the way that it should have been signed in 2010. But you probably want to think about updating it because the laws have changed. Typically, it's drafted so that it can be in effect, in force at the time of signing. And that means that I sign something today, it's effective immediately. Excuse me, my husband, who I have named as my agent, my husband could take that to the bank and be put on my bank account as my agent the same day. It is not linked to me being incapacitated. It's effective immediately. You can draft it so it's springing, which means it's a valid document, but my agent has no power until a certain event happens. And that could be that I'm incapacitated. It could be that I just don't want to manage my finances anymore. And I'm going to say, okay, I want this person to now act as my agent. But there are kind of 2 different ways that you can draft it. Effective at the moment it's signed, that person has authority, or springing based on some kind of future event. There are forms both for healthcare and finances, and we're going to give you the link, I think, in the next slide, that are created by the Department of Health Services. You can find them there. That document is drafted so that it is effective immediately. So if that's not what you wanted, you'd have to do something in that document and change it so that it's not effective immediately. The other part I want to make very clear is that when you are signing this document, you being the principal, me, principal, giving power to an agent, you are not giving up authority to manage your own finances. And so I think, Debbie talked about the clients that she works with where people might have, maybe they should have given power to someone else to take over their finances. They're kind of being subject to scams and giving away money and being taken advantage of. With a power of attorney, I principal still have the power to manage my own finances. I'm just giving someone else the authority to manage them as well. If you're in a situation where you kind of are falling prey to these scams, being taken advantage of, that's when it's someone else going to court and saying, hey, this person is essentially depleting all of their resources. We now need a guardian to essentially come in and manage everything and take away those rights of that person. All right, next slide. And Rhonda, if you have anything to add, feel free. So this is the form I was talking about. This is right in the statute, how the statute is written. This is the form through the Department of Health Services. Generally speaking, I think this form is missing powers that you might need as you get older. As an elder law attorney, this is not the form that I use. Again, it's also effective immediately. I think there's some confusion about the form at time. There are boxes where you can initial in certain powers, and you might think you don't need to check all of them, and you're inadvertently kind of missing some things that your agent might need to do in the future. So overall, I think it is good to see an attorney to get a more robust financial power of attorney.
And that is what I recommend to all of my clients, is that you have an attorney, an experienced attorney, draft the document, because they will have seen all the little things, that the caveats that happen as a result of an ill-documented form. So my recommendation to all my clients is, if you're going to have a power of attorney, you want to make sure that all your I's are dotted and your T's are crossed, and make sure that the document is assembled by somebody who knows what they're doing. I don't really care for this form on the state website either, because it doesn't add the level of protection that I prefer my clients to have. So.
All right, so next slide, please. Okay, so capacity to sign. I kind of talked about sometimes it's too late. For the most part, you need to be able to understand, what you have, what kind of general assets you have, and then who you're naming to sign, and understanding that you're giving them the power to be able to access your bank accounts, to pay your bills, potentially sell your house. That's all in this document. Now, I mentioned there's the different differences between a healthcare power of attorney and a financial power of attorney. The healthcare power of attorney is always drafted so that it's springing. So you sign it today, but really no one has any power until two doctors, or a doctor and a psychologist, or another advanced practice clinician say, you now lack the capacity to make your own healthcare decisions. It's very specific, just healthcare decisions. They will sign a document saying that essentially now your healthcare power of attorney has been activated. And so now your agent has the ability to make healthcare decisions. I do have people come into our office where that has happened. Oftentimes that is linked to a diagnosis for dementia, but perhaps we might be in early to kind of middle stages of that. And, they filled out a healthcare power of attorney in their clinic with their doctor, but never did a financial power of attorney. Is it too late to now do a financial power of attorney? And the answer, which is a very common answer for attorneys, is it depends. But it doesn't mean that just because your healthcare power of attorney has been activated does not automatically mean that you could never sign a financial power of attorney. Again, it's, do you have the ability to understand kind of what you own and who you're naming, and kind of what power you're giving that person? And kind of the way I like to explain it is, when doctors are sitting down with you and assessing to determine whether or not you can make your own medical decisions, that is one assessment of capacity. Can you make medical decisions, which might include, should you have surgery? Should you start a new medication? Should you go on hospice care, right? And that can be a very complex decision. Versus if you're signing a financial power of attorney, you might need the capacity just to be able to have a general understanding of what you have and who you want to handle that for you if you can't do it on your own. So I just like to put it out there that it is very possible that you could have an activated healthcare power of attorney and still sign a financial power of attorney, or you might not be able to sign a financial power of attorney. It really depends on, at the time you're signing, do you have the capacity? Do you understand what you are signing? All right, next slide, please. Okay, so if your financial power of attorney is more of the springing type, where we're saying agent only has power if I am incapacitated, this is the definition for that. It's a little bit bigger than just kind of what we've been talking about. It includes someone who's outside the US and who can't get back, someone who's incarcerated, missing. But really, when we're looking at incapacity, we're looking at, does someone have the ability to receive and evaluate information? Can they communicate those decisions? It's the taking in of information, processing, and then communicating a decision. And if they can't do that in relation to their finances or business affairs, that's when we're saying they lack capacity. All right, next slide, please. All right, so what is the power of attorney going to be doing? And I'm going to give you kind of the basics. And then as we move through this, we're going to talk a little bit more about that news story that we referenced earlier, where the woman was now living in an assisted living facility. She had a power of attorney who I think was an attorney. She had signed that document, 20 years prior. And now here we are in 2023, and that house is being sold by that financial power of attorney. So what are the duties of the financial power of attorney? One is that they are supposed to follow the principal's reasonable expectations. They're supposed to follow these even if they differ from the best interests of the principal. So I always tell my clients, if you're nominating your child as your agent, your child really is supposed to be they're acting in your shoes. What you would want to do, that's what your agent is supposed to be doing. They're supposed to act in good faith. They're fiduciary. They have responsibilities to manage your finances properly. And they can only act within the power of attorney. So whatever the document says, whatever the language in there and powers they're given in that document, they need to act within those powers. And so if you just want to go to the next slide, please. So this is an example of agents' duties. And this is in the state form, the DHS form, about what an agent is supposed to be doing. And so again, they act within their reasonable expectations. If you do not know those expectations, then you can act in that person's best interest. Again, acting in good faith, following the powers of the attorney. And the other key part is, how do you sign as an agent? I get this question a lot. As a general rule, you never want to sign anybody else's name. So I'm never going to sign my husband's name as though he is signing it. If I'm acting as his agent, I'm going to sign my own name, but I'm going to say, as the agent of, my husband. So again, we want to be very clear, you are acting as the agent. You are not the principal just signing their name. And then again, you're acting for their benefit, avoiding conflicts of interest. We want to avoid what we think of as self-dealing. So if I have, my house and my agent, my child decides that she's going to sell it to herself for $5 and she can sell it as part of my document, but clearly $5 is not the value of my house. That might be seen as self-dealing, right? She's getting a real benefit from being my agent. All these types of things are definitely frowned upon, to say the least, and not possible under this document. Next slide, please.
There's a provision in there where you can, set a fee to pay the power of attorney a certain fee. So with increases too.
Okay, so nominating an agent, you can name co-agents. That means if you have two kids and you can't decide and they both would be good at this particular job, you could name both of them to act. They can act independently or jointly. I always say you want to nominate a successor at all times, because what happens if something happens to your first agent and they're no longer available, then you don't have anybody nominated to fill this role. So it's always good to nominate at least one or two successors, and then that person can step in when the agent has died, is incapacitated, or no longer is qualified to serve or resigns. And Rhonda's going to talk a little bit later about all the different qualities for an agent that she looks for.
And I think you can assign a successor. You put the language in there to assign so that the agent can assign their own successor as well, correct?
Yes, that's also in there. Mm-hmm. But if that agent has died before they were able to do that, then we don't have a process to get somebody new.
Amy, I don't understand the difference between reasonable expectation and best interest. What's the difference there?
Yes. So the woman in the news story, for example, right? She might have had a reasonable expectation that even though she hadn't lived in the house for a number of years, it's what I'm gathering from the story, and she was now in a facility, that she always expected that house would always be there and it would never be sold. So that was what her expectation was. And that might have been somewhat reasonable for her to know that that house could always be there as long as she had the money to keep it up, right? But in her best interest might be different. Her best interest might be to actually sell that house so that she could pay for her care at the facility. Or maybe she had a lot of medical bills and she needed more money, and the only way to do that was to sell the house. Maybe the house needed extensive repairs, right? We need a new roof, new furnace, new driveway. You know, it would not be in her best interest for her to spend $100,000 fixing up a house that she wasn't going to live in when she could have used that money to pay for her facility. And I'm making this up. I do not know this person. I'm just giving examples of how a reasonable expectation might differ from somebody's best interest. Does that make sense?
Is it a higher standard or anything like that? Is there any hierarchy of virtue in these two criteria?
I mean, reasonable expectation is the standard. So that is the standard that the agent should be operating under.
Okay.
I would say if there ends up being a conflict about what the principal might want, what the agent might want, and maybe what another person might want. So maybe there are two children, one is the agent is going to do one thing, the other child wants something else. There really isn't very much court oversight POAs, which I think is why it can be a little bit scary sometimes for people. Guardianship, there's definitely oversight, but for POA, someone has to actually go to court and say, court, I want you to review the conduct of this agent. I don't think that they're acting within, you know, the reasonable expectations or even in the best interest of this person. So
it also depends on capacity of the principal as well. If they're asking you to do something that is unreasonable, but they're asking you to do it because maybe their capacity isn't, their decision-making capacity isn't well, you know, you got to take that into consideration. If in the example of the lady selling the house, she didn't understand why the house was being sold and she was asking to keep it, but she was never going to return home and the house was falling into disrepair, and so he was selling it to pay her medical bills, for an example. Well, that's making, you know, she's making an unreasonable request of him, you know, in that situation. So
Oh, okay. Thank you.
you ready for next slide?
yeah, thanks. So I talked about acting within the scope of the document and the powers. And so there are a number of powers that the statute provides. So real estate is one of those powers, bank accounts, businesses. Essentially, you are saying, yes, I'm giving my agent the authority to basically take over these powers or manage these assets for me within this document. Do you want to go to the next slide? And so these are all of the different kind of headings of powers that we are giving our agent. And so that includes, again, real property. TPP is just tangible personal property. So that's just kind of, you think of as your stuff, car, vehicle, snowmobiles, those kinds of things. Operating a business, applying for government benefits, managing government benefits, accessing retirement plans, paying taxes, all those kinds of things. These are kind of the very broad categories of powers that are in the document, in that statutory form, to give someone else the power to manage something within these headings. So they're pretty broad, right? So it's not going to get into the detail of when someone's house could be sold. It's just saying, yes, I give my agent the ability to manage my real property, my real estate, those kinds of things. Now, if you want to give your agent certain powers, and these are kind of the powers I've listed here, gifting is one of them. If you want your agent to be able to make a gift of your money, that has to be very explicitly written in your document. So for example, if I want my agent to still be able to give my kids $10,000 each year at Christmas, and now I'm incapacitated and I can't do it, that would need to be written in my document. This is here because gifting, I think kind of clearly it could be a problem for some people where they decide now that, oh, you know, I've really been taking care of mom for, you know, the past year, you know, I'm not really getting paid for this. Mom would have wanted to pay me, you know, $50,000 to do things for her. So I'm just going to give myself $50,000. You can see where that might become a problem. And so if you want to have, there are certain reasons why you might want to have gifting, but you also want to make sure that it's a very clear power, clearly delineated, and kind of what you want that gift to be. You know, I talk to my clients about this gifting power and say, you know, I never want to say that anyone's kids are bad kids, but your kid might find him or herself in a situation where it is going to be very tempting to see that $100,000 in your bank account and say, oh, I might just tap into that. And it might be for valid reasons, right? They're in an accident, they've lost their job, and now they need some money to pay bills. They've got college, they've got house repairs. We just want to make sure that if we're talking about gifting, you're putting that in your power of attorney, that you're really thinking through what that looks like.
And I like to suggest
go
that
ahead.
folks, if you're going to do gifting, they say gifting be allowed up to a certain dollar amount at the discretion, because, you know, if you're running low on funds, you don't want your family to assume they're going to get the gift. As a power of attorney, I would want to say, well, there's not funds for the gifting. So I want to be able to have that ability to just kind of say, well, I don't think we'll be able to do that this year anymore or going forward or something.
Right.
So you want to have language in there specifically to address it.
And I don't have a lot of clients who are doing, you know, certain gifting to kids every year. A lot of my concern is for someone who is applying for Medicaid, you know, long-term care, living in a nursing home. And that's, again, probably a whole nother topic. But if someone is kind of in that place and applying for Medicaid, I need to be very careful about gifting, because that could be a penalty when you apply for Medicaid. So again, we need to be thoughtful about what kind of gifting we're doing, what powers we're giving to someone, because an agent does have a lot of powers, as I hope we've kind of seen over the course of this presentation. And then I have at the very end, this probably isn't going to make a lot of sense to a lot of people, about the specific power to create and fund some kind of a trust. That is a pooled special needs trust. That is part of kind of the Medicaid planning and work that I do. If you want your agent to be able to do that for you, that also has to be in that document, which is why it's good to seek out an attorney who kind of knows this area, because that's a power that would also need to be written into the document if you're ever in that situation where you're applying for Medicaid. And that's a way to really qualify for it.
And just to explain that, a special needs trust for that situation is so that you can qualify, you don't disqualify for Medicare if you receive a lump sum of money or for something like that. It allows you to qualify for Medicare, but you still get to keep this pool of money. Maybe it was an inheritance or something, but it is determined that in the event of your passing, the funds go to, you know, Medicare. Right? Did I explain that correctly, Amy?
Yes, that's one way I'd use that trust. Yes, to stay on Medicaid. Yep. All right. So gifting, again, you want to be very clear about that gift. You want to put some limitations on it. If one child gets a gift, all the other kids are going to get a gift. And then if you have a pattern of gifting to charities, churches, your agent can follow that as long as you've written it in your document as well. And again, we need to demonstrate a pattern of, you know, this is where I have been giving money. I want you to be able to continue to do that. All right, next slide. All right, digital property. I'm not going to spend too much time on this. I think this is kind of one of these looming issues, right? The more and more we move our lives over to the digital world, right? You have to pay to get bank statements printed now. Everything seems to be online. Ultimately, if you want your agent to be able to access content of electronic communications, so if you need them to get into your email, for example, for some reason, that has to be written in your document very explicitly saying, I want my agent to be able to do that. I just kind of put in a plug here for legacy contacts. So things like Apple, Facebook, Google, they can allow you to set a legacy contact, which means if you pass away, that person can go in and they can just shut down, memorialize those accounts. There have been some strange kind of Facebook scams after people die, going in, asking for money. So again, if someone is no longer alive, it's a good thing just to kind of shut down those accounts and kind of cut people off at the pass. And then I always advocate for using a password manager if you can. It's a safe way to kind of keep your passwords organized. And they don't have a legacy contact though, but the other Apple, Facebook, they do, where you can just name somebody to kind of shut down those accounts for you. All right, next slide. I don't want to run out of time. So I mentioned that there's very little court oversight over powers of attorney, and only specific people can go into court and say, I want you to review this agent's conduct, and I want you to what we call construe a power of the power of attorney, saying, gosh, the power of attorney, the agent is doing this. I don't think that document actually lets them do that. I want you to judge to weigh in on this. And so the principal can always do this. The agent can always do it. A guardian could do it. A spouse, a parent, a presumptive heir. That just means if you've got kids, your kids are also presumptive heirs. The caregiver, someone who is asked to be accept that power of attorney document, and also adult protective services could ask for this as well. So it's a fairly narrow group of people who could ask for court oversight over this power of attorney. All right, next slide. In general, the person who accepts that power of attorney document, they are acting in good faith that the document is valid. So if a bank gets that power of attorney, they are supposed to treat it as a valid document. There are only limited circumstances where they're supposed to question it. I will say I do get questions from banks, not always about the validity of a document, but just saying, oh, we have our own power of attorney form. We want you to use our power of attorney form rather than this one. But by and large, they are supposed to accept them as valid documents, and they cannot mandate that their own form be used. We want someone to have what we call kind of a durable, long-lasting power of attorney that is going to cover all of your financial institutions. It would be a real pain in the neck to have to fill out one of these at every single place that you go. And it's defeating the purpose of doing estate planning and having you go to an attorney where they just create this financial power of attorney document for you, and you can then use it at all the different places. All right, next slide, please. All right, so Rhonda's gonna talk a little bit about kind of how do you pick a financial power of attorney, and then we'll talk a little bit more about that, the news story that we mentioned earlier.
Thanks, Amy. So what makes a good attorney? So we've decided we need to get a financial power of attorney. How do I pick one? It's important that you pick somebody who's been vetted and is trustworthy. And we've all heard several stories about, well, as a daily money manager, I have stories. You know, I get people calling me all the time. My uncle's in Florida and his neighbor was helping him out and took off with all the money. I think somebody mentioned that she knew a couple of cases of that happening in the introductions this morning. So there's cases of that happening all the time. Is a neighbor that just was helping out. So you want to make sure that whoever you assign for this big role we've already discussed, that they're vetted and that they're trustworthy. You want somebody who's bonded. So for example, I'm a daily money manager, but I am also bonded. So that's an extra level of insurance where you have that background check. The insurance is kind of guaranteeing that if something were to happen, let's say your power of attorney decided to take off the money, having them bonded, that is just that extra insured, is that extra level of protection that you may get some of those funds back. Somebody who's willing to be an advocate for you, because let's be honest, you need somebody that's strong enough that's going to say, no, that's not what they wanted. Or just, you know, for example, you have a family member that insists that there's, you know, there should be a gift of $10,000, but you've only allotted $3,000 in your power of attorney paperwork for gifts. That person needs to stand up and say, no, that's not how the document is written. So they need to be a tireless advocate for you. Compassionate, have a servant's heart, somebody with a background check, So you just really want to make sure that that person's been really vetted, not just a helpful, friendly neighbor. Sometimes I've seen in senior housing, some of the worst problems of somebody being taken advantage of came from their family members. So just because their family doesn't mean that they're always the best person to take over your finances. I saw a lot of arguing among family members. Somebody passes away, and now the rest of somebody was the power of attorney. They pass away, and now the families are like, where did the money go? Well, in reality, you spent the money on mom or dad, but they think there should be a ton of it left because they're not there paying the bill. They don't know. So what I tell folks is a lot of times in the event of your passing, you want your kids to come together and join together. You don't want one of them to be the bad guy. That's where somebody like me comes in. I'm the bad guy. Your family's united. They're going to stay united. When I'm out of the picture and everything's closed, I'm no longer in the picture. Your family is still united. I'm okay being the bad guy. So, you know, those are just some things to think about. Money does really funny things to people. So.
Yeah. And if I could just add with that too, you know, it is hard to find someone to serve as a financial power of attorney that is not family. There are a lot of banks don't really offer this service. If they do, they charge for it. We are really looking for someone like Rhonda who understands what a financial power of attorney does, to step into that role, especially where I have clients who really don't have anyone, except for maybe older siblings, which, you know, they're not comfortable naming. They don't have anyone to kind of step into that role. And I would say the same for healthcare power of attorney, as there are some agencies that will serve that role for somebody, and that kind of takes away the decision-making for the family member. But even those are kind of few and far between. We just don't have, I think, the resources for kind of independent people to fill into these roles.
And the reason I offer it is because I had attorneys and other people telling me, well, we can't find anybody who will do it. And I guess I'm a tireless advocate for seniors. I just feel like if I don't offer it, who will? And whoever they get might not be the most honest person in the world. So that's why I do it. And so that's when you're looking for somebody to be your power of attorney, you just have to find somebody who's going to be who's a tireless advocate for elderly. Or anybody. So our next slide, we're going to actually spend some time talking about the article. It is 10:49. We have about 10 minutes. So what do we think happened with this story that was in the news? We won't ever hear, I'm sure, from the power of attorney because they need to follow confidentiality rules. As a power of attorney, as the daily money manager, I'm not talking about what happened with my clients. There's no way I would open up about that. So I'm sure that's why you didn't return the phone call. Sometimes if the power of attorney needs to be activated, that's usually activated due to decline in mental ability to make decisions, correct? So my first question when I saw that article was there's a reason why the power of attorney is in place and activated. So also, okay, the niece was living in the house, right? Was she taking advantage of the lady in her diminished memory, so that was the next question I asked. More often than not, like I mentioned, I see it's family members taking advantage of mom or dad or aunt or uncle or whoever they're entrusted with taking care of. So the county has to step in and protect them.
But in this case, Rhonda, we don't know anything about the person who is in the picture here, so we don't know anything about her, right, or her motivations. She was just part of it.
We don't. So I'm just giving ideas of things that might have been occurring.
Okay.
So was the power of attorney required by Medicare or Medicaid to sell it, or the healthcare facility to sell the home? Often that is the case. They need to pay for continued care. So if the home is the only asset left, the power of attorney may have been required to do that so that that person could continue to live in the home. So even though the woman had the expectation of having her home as an option to go home, it just may not have been a realistic expectation. And I would hope that the power of attorney would have discussed that, but maybe the niece, it sounds like the reporter was the one that was doing a lot of speaking up, and so she maybe had a vested interest in that home. I don't know for sure. Those are just ideas that come to my mind when I read that article. As Paul Harvey would say, the rest of the story, right? Did he have a right to sell it? I guess it depends on the power of attorney form. What did the document say? None of us have seen it, so we can't speak to the right of whether this specific power of attorney had the right to sell that house, because it really just depends on what specific were in that power of attorney form. Correct, Amy?
Yes, and really most forms I see, it's a pretty broad power to sell your real estate. I would think at a minimum, the power of attorney would have contacted the woman, contacted family, and just at least inform them of kind of the decision tree of how he or she made the decision to sell the house. You know, selling a house is a process. You don't just put it on the market one day and it's for sale the next day. You have to potentially clean it out, get it ready for sale, list it, take the pictures. I mean, there are a lot of steps that go into that process. So I feel like we're missing a lot of the facts here.
And could he have sold, you know, wouldn't it have been likely that he told the niece, hey, I have to sell the house to pay for the nursing home or whatever. Would you be interested in buying it? I know that would have been the first call I would have made, you know, to family, asking them if they would want to buy it for market rate.
Mm-hmm. Yep. Yep. And I think this story is informative. My takeaway from it is I don't want people to be scared in not signing a power of attorney because of this story. I don't think we have all the facts about what the power of attorney did. And really, again, if you're picking someone to act as your agent, they are supposed to be acting in your shoes, at least as long as we're meeting kind of those reasonable expectations. There might have been a reason why this was sold in order to protect her best interests. But ultimately, the agent should be working, with that principle in making decisions.
In tandem, yes.
In tandem, yes.
What are the penalties for violating a power of attorney here? Let's say that the power of attorney sold it to himself for a good deal. What are the penalties?
Well, then either the principal, so the woman, or one of her heirs could have gone to a court and asked for a review of the agent's conduct. Now, if the house has already been sold and closed on, you're going to enter up a whole new area of legal woes, because now, what were you telling the potential sellers and their agents? Are we saying we never had the authority to even list it for sale? So, but that would be the avenue, is asking for a review of that agent's conduct.
One thing I think about is why, as an agent, now if I list a house for sale, now I'm responsible for making sure that it gets cleaned out and ready for sale. I mean, that's a lot of added work for me to do that. So that's just something to consider, in that. So.
Hey, Amy, I have a question. Sorry, my background's not working very well with my camera, so I didn't have it on. I'm actually working with these people who are in the article. How do they request a review of the agent's conduct? Oh, you're on mute. Sorry.
There is a petition for the court. I don't recall if it's on, the WI Court's website, but essentially there is a petition to ask for a review of an agent's conduct. And if I can find it in the time we have, I can try and put it in the chat box.
Okay, thank you.
Amy, can I ask a question?
Go ahead.
I'm wondering if you could clarify, earlier you mentioned that co-agents on a power of attorney for finances have an ability to act independently. And I wonder if you would discuss that a little bit further, because I work for Dane County Adult Protective Services. It's always been my understanding that depending on the actual language in the document, typically co-agents are not able to act independently. And we typically don't advise co-agents, because unless they agree and get along, it's very problematic.
Mm-hmm. Yep. So the absolutely depends on what the language is in terms of individual or joint powers and what decision-making power they each have. I don't know that if you did the state form, you would have co-agents anyway. But I would have to look at I think the default is that these agents can act, and I'm just looking this up here, that they can act individually unless the document says otherwise. But let me just take a quick look at that.
I also noticed that when I clicked on the link in the PowerPoint slide, and I don't know if you can attach the PowerPoint slide, Mike, to the video so that people can download that, or at least the PDF version of it. But when you click the link, it actually will take you to the state website, and on that state website, if I remember correctly, there was a link to request the review. So I was looking at that last week when I was drafting this my slides. So.
All right, so I just posted the language that talks about, unless the document provides otherwise, each co-agent may exercise its authority independently. I also am not a huge fan of co-agents. I've gotten pushback from banks about co-agents, but in some cases, people feel it's the only way to kind of keep the peace, and that's what they really want to see, is having two kids, and then if one can't do it, the other can step in. It should be a thorough conversation with the client if you're going to have co-agents.
Can they assign a hierarchy of agents? Like, okay, if we can't agree, this particular person is the decision maker. Could they put that language in there?
You could, yes. But then it would just take every organization to kind of follow that hierarchy as well. So there is a question about POA being activated versus someone just assuming those duties. That's a whole other can of worms. I feel like this does happen not so much in the financial world, but in healthcare. Oftentimes, I do hear of stories where, I'm not the healthcare power of attorney, but the doctor is just working with me, right? Because we need to get this done. That is okay typically for kind of an emergency situation, but that should not be the default if you don't have that power of attorney in place.
I'd like to ask I'm sorry. Can I ask a question? Sure. This is Emily Krieger. I'd like to ask if an out-of-state power of attorney is accepted in Wisconsin. For example, my parents set up, they lived in a different state, they set up a POA, and now they've moved to Wisconsin. Do they need to create a new one, or is that still accepted?
Sorry, I said unmute myself there for a second. So as long as the document was valid in the state that it was signed in, it is considered a valid document. There is a reason to at least have someone in Wisconsin, a lawyer, someone who understands the laws here, to make sure that you still have everything you need in that financial power of attorney for the state of Wisconsin. So, in Wisconsin, we have it notarized. In some places, maybe they have a different way of getting a financial power of attorney. As long as it was done properly in that state, it is a valid document. I will say for healthcare power of attorney, I usually recommend just getting a Wisconsin healthcare power of attorney and not relying on the out-of-state one, because Wisconsin has some very specific language about placement in a nursing home, placement in a community-based residential facility like an assisted living facility. And you do need that language in there in Wisconsin. And so financial, I'd have to look at it to see whether or not it still kind of cuts the mustard here. But for healthcare, it may or may not. You want to make sure you've got someone who knows the laws to understand that it's going to work for someone in Wisconsin.
Any more questions? We're right here at the edge of the hour. Any other before we sign off?
Yes,
Go ahead.
I have one more question regarding financial power of attorney and healthcare power of attorney. Should they be created as separate documents, or should you create
Yes.
one power of attorney that has separate, provisions for both?
They are two separate documents, absolutely, and they have different signing requirements. So in Wisconsin, your healthcare power of attorney needs to be witnessed by two disinterested people. So anyone who's not related to you by blood, marriage, or adoption, or is not going to inherit anything from you, those people cannot be witnesses for your healthcare power of attorney. I guess with the idea that they might be motivated to end your life sooner rather than later in order to get, something from your estate. And so that is, two witnesses. Again, for financial power of attorney, it would be notarized. And so they should be two separate documents.
Any others?
I do have our contact information up on the slide. If you should choose to contact either one of us, just mention that you participated in this program, so we just kind of know how you're reaching us through.
Super. And I want to thank you, Rhonda and Amy, for taking the time and lending us your knowledge here. Really appreciate it. It was a great hour. Thank you, everyone, for joining us today.
Thank you. It was wonderful being here.